In today's video, we're going to discuss 7 common scenarios where a will is challenged. If you find that one or more of these situations is in your case, you may be in a position to seriously consider challenging the will. These are not all of the possible reasons to contest a will, but they are some of the more common ones. My name is ERIK BROEL, and I'm the founder and CEO of Georgia Probate Law Group. At our firm, we help families who have lost a loved one navigate the complex and confusing legal process so they can make sure the estate is handled properly and their loved one's memory is honored. We've done a lot of work with will contests, and we have helped hundreds of families through these difficult situations. Now, everything discussed in this video is for general information and is not legal advice. For specific information about your situation, please contact our office to set up a consultation. If you'd like more information about Georgia probate topics, click the link in the description below or go to our website, www.georgiaprobatelaw.group.com. While there, be sure to download our Georgia Probate Handbook so you know how the estate is supposed to be handled. For our topic today, what are the 7 most common reasons to contest a will? Sometimes when a will is revealed, you'll feel shocked or you'll feel hurt by what it says. And usually that shock and that hurt is not enough on its own to support a legal challenge to a will. If, however, there are one or more of these 7 situations in your case, a will contest may make sense. So, what are they? Number 1, you feel that the will is a fake or that a fraud, and you have some kind of proof. For example, you look at the signature page and the signature on the will looks nothing like the deceased's signature. Number 2, the wishes expressed in the will are nothing like the wishes that your loved one openly discussed with family or with friends. Perhaps the will was changed shortly before death or even on their deathbed. And the desires that are expressed in the new will are radically different from what was expressed in prior wills or what was expressed for a long period of time. Number 3, there was a person who was around your loved one all the time, and they were exerting inappropriate influence. When you read the will, it appears that the will is really what that person wanted, not what the wishes of your deceased loved one were. This type of case can be even stronger if the person also helped your loved one create the will. In addition, if the person inheriting under the will is not a close relative or someone you would expect to inherit, then it's cause for additional concern. Scenario number 4. When you look at the will, it's missing signatures. In Georgia, a will must be signed by the person making the will as well as 2 witnesses. So if the will is missing any of those signatures, it's worth looking into. Quick note, in Georgia, we do not require that a will be signed by a notary. Scenario number 5. You believe your loved one made a will that is dated after the will that has been filed with the probate court. If you believe the newer will can be located, then that can be a viable reason to object and have the older will declared invalid by the probate court. Scenario number 6. You believe the deceased destroyed their will, but a copy of that will has been filed with the probate court. Now, just because someone made a will once does not mean they're forced to keep it forever. If there's evidence that the deceased destroyed the will prior to death, it can help to invalidate the copy that's now been filed. Finally, scenario number 7, our last scenario. You believe that your loved one lacked capacity to sign the will. Now, this is one of the hardest ways to overturn a will because Georgia law is very flexible with whether someone has the mental capacity to sign a will. In fact, if mental capacity can be found for just a few minutes while the will was signed, then that can be enough to uphold the will. That said, if evidence can be found showing that the deceased did not have mental capacity at the time the will was signed, then the will can be invalidated. All right, that's it. Those are the 7 most common reasons to object to a will. If you found one or more applies in your situation, you may want to look further into filing an objection to the will. Each of these situations is different, and they are all complicated. So if you're in a situation where you believe you need to contest a will, I recommend you find a qualified probate attorney to help you. As always, thank you for watching.